Well, welcome to session 3. The Constitution is a Bill of Rights. That's a quotation which is uttered by the Federalist side in the debate with the Anti-Federalists. The Federalists, those who supported ratification of the Constitution, and the Anti-Federalists were those who opposed ratification. Well, but we'll get into the details of the ratification debate and its impact on the Bill of Rights after lunch in session number 4. But this one is looking at what happened at the Constitutional Convention during those 88 days, and what happened in part during the pamphlet war that was unleashed between the Federalist papers written by Publius and a number of anti-Federalist essays written by Brutus, etc. Look, notice the nomenclature, the Roman pseudonyms. Publius is a person who saved the Republic. Hamilton rather imprudently used the name Caesar to defend the Constitution. And very, very quickly, a New York anti-Federalist decided to launch essays called Brutus with the idea of finishing off Caesar. And then James Madison came along and told Hamilton to be prudent. Why don't you choose the name Publius, who is known as the savior of a republic? Anyway, that's so the Constitution is a Bill of Rights. Hamilton is well known for uttering that in Federalist number 84 right at the end of the Federalist Papers. And James Wilson is known for uttering it right near the beginning of the campaign of when he stood at the State House steps, which is right behind the Independence Hall, and looking into that nice picnic area in Independence Hall, and that's where he gave his State House speech. But the argument, I would think, hasn't resonated very well with the American people then, scholars today, and here's the argument and why it doesn't resonate. The argument is that in a federal constitution, that which is not granted is reserved. Therefore, if a power is not granted, that is, if you don't see it explicitly, it's not there. How do you interpret silence? It's not there. So you don't need a Bill of Rights. So if you did have a Bill of Rights, first of all, it's unnecessary, because if it's not granted, it's reserved, so you don't need a Bill of Rights. And secondly, it's dangerous. And it's dangerous because what happens if you miss one? Then you'll imply that you didn't have it to begin with. So that if you forget, for example, if you don't list the idea of the right to privacy, let's say, well, then if you start this listing game, then I guess I can presume you don't have the right to privacy. Well, it's a certain, I think there's a certain ingenuity about this argument. And the ingenuity is that the framers didn't create anything different than the Articles of Confederation. There is no Bill of Rights with the Articles of Confederation, which is the first continental-wide government. And the reason why there is no Bill of Rights is not that the framers of the Articles were backward. And we have this English and colonial heritage, we have the revolutionary heritage that we've been through in the first 2 sessions. Not at all. It's that the Articles of Confederation state that the Union can only do those things which are expressly stated. So if it is not expressly stated, the Union can't do it. So in a sense, the Articles of Confederation is a Bill of Rights. Because what is the point to a Bill of Rights but to say, you can't do this. You haven't been granted the power. So under the Articles, you don't need a Bill of Rights. But isn't changing the Articles what the whole Constitutional Convention was about? The answer is yes. So it's a bit ingenious to use the argument that the Constitution is a Bill of Rights because the Constitution is like the Articles. Okay. Hamilton had another kind of argument. I think Wilson did too, but not as powerful as Hamilton. The argument is that what is the point to a constitution in the first place? The point to a constitution is to establish the rights of the people over against, say, monarchy and aristocracy and papacy, all monopolies, monopoly in government, monopoly in economics, monopoly in religion. It's to establish limitations on monopolies. And therefore, there's a sense in which a constitution is a Bill of Rights. It's a right of the people against monopoly in economics, monopoly in government, and monopoly in religion. So a constitution is one, for goodness sake. The whole tradition of the Bill of Rights is constitutionalizing things. So we've got it. We win. It's a Bill of Rights. So why do you want a Bill of Rights on top of a Bill of Rights? Doesn't make sense. Gotcha. Yeah, there's that one I think makes a bit more sense to me than the first one, because clearly the frame was moved away from the Articles. But the second one makes more sense in terms of the tradition of the Bill of Rights is where the many have been trying to restrain the one and the few. Take Magna Carta. The nobles, sort of, there are more of them than there is of the King John. The many constraining the king. The Petition of Right in the 1640s, it's the Parliament trying to constrain, or the Lords trying to constrain the king. And in 1688-89, it's the Parliament trying to constrain King James. So that in all three instances, this movement for a Bill of Rights is a movement in favor of democracy or the people. But hello, we're living in the 80s, not the 70s. We won the war. We've won the battle. So why are you talking about having a Bill of Rights when the Constitution is a Bill of Rights? Because that's the whole point. Well, Ed Meese revived that a bit in the 1980s during his debate with Brennan to try to restore, I think, really, the similarity between, the compatibility of the Bill of Rights to the Constitution, because by then, in many scholarly circles, if not judicial circles, there was this battle that had been set up between the Constitution on the one hand, which is power, and the Bill of Rights on the other hand, which is rights. And so we got this conscience versus power again sort of battle. And I think Meese tried to recalibrate that battle. So the Constitution is a Bill of Rights is a phrase which comes out of this Federalist, anti-Federalist debate. Now, Hamilton had a third argument. Okay? The third argument is that the Constitution contains the most important rights. These are three. He said, will this fly? Try this one. Try that one. And I think the first one is weak. I think the second one is stronger. And I think now the third one gives the anti-Federalist opposition their best crack. And that is, Hamilton says, look, the most important rights are the right to habeas corpus relief, the right to no bill of attainder, the right to no titles of nobility, the right to no ex post facto law. Those are fundamental rights of the people. And what we're talking about is that these are rights concerning political process. And in the Constitution, yes, in Article 1, Section 9. And by the way, that's exactly where we think we'd expect to find it. Because Article 1, Section 8 lists the powers of Congress. So, whoa. If we are thinking now along what we've been thinking, we would expect if the Constitution starts listing, billing rights, it'll do it in Article 1, Section 9, right after listing, billing powers. So that having said what Congress can do, regulate interstate commerce, tax, spend, army, and all things necessary and proper for carrying into execution the aforementioned powers, those 18 listings of powers, that if we're going to say that what Congress can't do, it's going to come right next to Article 1, Section 8. And sure enough, there it is. And then in Article 1, Section 10, the U.S. Constitution indicates that this is what the states can't do. So what Congress can do, Article 1, Section 8. What Congress can't do, Article 1, Section 9. What the states can't do, Article 1, Section 10. So Hamilton is saying the Constitution contains the most important rights. Blackstone, common law, political process rights. Well, I think that gives the Anti-Federalists some of the best ammunition, because they would say, well, why have you included some and not others? And the answer is because we've included the most important. And then it goes back to the first one, and there, et cetera. If you don't grant it, then it's reserved, and if, et cetera. So that's the title of what we're going to be talking about in this third session is The Constitution is a Bill of Rights. And there are three component parts to this argument. And it comes out of Wilson and Hamilton. Now, what I have done, with Lisa's help, you'll take a look, is that if we go to the Constitution, the rights that are contained within this Constitution, what I have done is to actually take, say, Hamilton and Wilson at their word and see whether or not we can flesh out some more rights that are in the Constitution. And that a bicameral legislature. Now you say, well, that's not really a right. Come on, we're used to, when we talk about Bill of Rights, we're not talking about a bicameral legislature. Well, back then, a bicameral legislature was viewed as a right of the people not to have a unicameral legislature, because a check and balance is considered to be a political right. At least one could make that argument. And I think one could make that argument, and I am. Article 1, Section 2, the right to run for the first branch. That is the right to be a representative. And what good is representative government if you've got incredible property qualifications? But if you look at the Constitution, there's not a lot of... You know, when I think of France, to go back to the French example, you go up to somebody in France and you say, "Good morning, citizen." You know, and in the Soviet Union, you would have said, "Good morning, comrade." But you don't say citizen or comrade in the United States, right? We don't take citizenship as seriously as the French. By the way, one of the longest sections in the early French Constitution is defining what a citizen is. And what it takes to become a citizen, and how your citizenship can be taken away from you. To be a citizen is something essential. I mean, it's you being a member of the city. It's just like being a member of a class, except that the class is the nation. And I would say that the right to vote for the first branch in America is very minimal. I mean, if you can vote in the Assembly, you can vote for the Congress, you can vote. Basically, it used to be 21 and male, no property qualification. I mean, to us, it doesn't look democratic. But if you take it at the time and you look upon it as roots and you move forward, rather than read history backward, you read history forward as it's supposed to be read, then what you find is that the most democratic electorate in the history of the world. Roots. One would hope then that the roots shall expand to include other people as time marches on. But the right to vote, the right to participate, the right to representation, all of those are rights. although not rights that we normally today consider to be rights that are listed in a Bill of Rights. But I would say that with a broader understanding of a listing of rights, I would put them there. It's certainly counteracting monarchy or counteracting dictatorship, or on the other extreme, counteracting direct democracy, which is introduced into this country essentially by the progressives at the referendum and right. So you've got, if you're going to have a representative democracy or a democratic republic, these are important. The right of Congress, members of Congress to free speech and debate. How can you have a legislative branch if the members of Congress aren't free to speak and debate and not be held responsible for what they say and be taken to court for it? I mean, we don't do that now. So writ of habeas corpus, that's what Hamilton is particularly interested in. And we can go down. And so there is some sense then, having criticized this position that the Constitution is a Bill of Rights, I am now, point number, this is the second big point, is try to defend it by saying that it is possible with a broad understanding of rights to see the Constitution as containing a number of rights which were taken seriously then, but don't seem to be a leading part of the lexicon of rights today. Okay. What I not want to do now is to turn to the claim of the Anti-Federalists, which is the Constitution as it leaves the framers' hands in September the 17th, 1787, does not contain a Bill of Rights. Right. So this is going to be their case against what we've been talking about for these 15 minutes. And if you go there, I think a point of departure. This is where we would go for the actual debate. But what I want to do, Lisa, is to go two steps further back, and I want to start off with the I want to go to the four-act drama. And the Constitutional Convention as a four-act drama is something that I've put together for. Isn't she fantastic? Yeah, she is. What I've done here is to try to make the Constitutional Convention manageable and understandable. It's over 1,000 words, Madison's commentary, day-by-day account. It's absolutely among the best literature that America has to offer, but it's political literature rather than fiction. It's real. I would put it at the level of the same status as Plato's Republic, except that Plato's Republic is about 6 people talking one rather drunken evening, and Socrates always wins, and in the end he becomes king, whereas in real life he's killed. This here is a real life drama with 55 real live people debating and deliberating, and Madison has it captured. And he worked on it for probably as long as Plato worked on his Republic. And I just think it's an absolutely fantastic contribution that Madison has made to the dialogue, the conversation that took place in Philadelphia those 88 days. But it's 1,000 pages. And it's tough slogging. So what I've done is to break it down into a 4-act drama. And Act 1 are the alternative plans. And what Madison does is to lead with all the rules, right? But then in Scene 2, there's the 15 resolutions of the Virginia Plan, or the Randolph Plan, as it's sometimes called. Now, this Virginia Plan is very important. It comes from Madison's hand. And here's what Madison is getting at. in the state of Virginia from 1776 to 1787, we have a Bill of Rights, a prefatory declaration of rights, in which the rights of conscience, the right of property, and the right to no habeas corpus, all that kind of political rights, are clearly stated. I am here to tell you that between 1776 and today, over these last 11 years, those three rights have been violated. And they've been violated despite the fact that we've had a Bill of Rights. I mean, how do you have a Bill of Rights, listing rights, to be enforced against a majority that has the power? How do you do that? I can understand. You can have a Bill of Rights enforceable by a majority over against a king. But how do you enforce a Bill of Rights to restrain whom? A majority? Against a majority? It doesn't make any sense to me, he says. And here's why it doesn't make any sense to me. Because in a democratic republic, the danger, the primary danger, comes from the tyranny or unjust or disgusting behavior of the majority themselves, rather than the disgusting tyrannical behavior of the few whom we elect. The greatest danger in a democratic republic is the democratic republic, the Pogo principle. And so he says, a Bill of Rights won't do much good in that situation. In fact, I'll tell you, it's useless. Because I can show you that the people, in the name of the people, have established a church in Virginia, thereby violating right of conscience. Established church is a violation of conscience. They've done it. Why? Because they can. They've also violated property rights. How have they done that? Paper money. Oh, you don't like paper money and democracy. No. Madison says, look, a contract between a creditor and a debtor is a contract which must be fulfilled. Otherwise, we just have chaos in markets and all over the place. So that contracts have got to be agreed to. But they're doing it all the time, and not only in Virginia, but up and down the nation. Majorities are making debt, going into debt easy, and majorities are making payment of debt easy, and they're canceling debt all over the place. So economic rights. And then, how about political rights? People are passing ex post facto laws, bills of attainder, all of it. So let's stop and think. Our rights from the Revolutionary period, the rights of the Declaration of Independence, the rights of the Virginia Declaration of Rights are in danger. A Bill of Rights is doing no good to protect those rights. What then must be done? The answer is to create a strong federal government with the capacity to protect rights. How are we to do that? Let me propose something. The Virginia Plan. The Virginia Plan virtually removes the states from an important role to play in the government. Remember, they are the government under the Articles. What's not granted is reserved to the states. Well, that's not going to go over too well because the states are there. They've just been turned from colonies into states, and nobody's really raised a question about that. How did that happen? It happened. And so a complication in our story about the Bill of Rights is that we don't only have the issue of individual rights, we now have states' rights. And that complicates the American story of a Bill of Rights. And we need to factor that in. So that the New Jersey plan is a plan which says we agree that the Articles have problems, but it's a powers question. Give the Articles 2 more powers, and we can go home. Madison is saying the problem with the Articles is that it's a systemic question. We need to change the structure of the Articles. Not just change the powers, we need to change the structure. So, the New Jersey plan says, change the powers, keep the structure. We don't need a Bill of Rights as long as we keep the structure. Are you following me here? Why does a Bill of Rights enter this conversation? Because a new kind of stronger, more powerful, structurally operative federal government is being created. That's the reason why you need a Bill of Rights against that federal government. You don't need one if it's a weak, limited, clearly confined enterprise. So you've got Madison arguing for a structural change. You've got the New Jersey folks arguing for a powers change. And Hamilton argues for a structures and a powers change and upsets everybody and they decides to go home until people get serious. And then he'll come back from New York where he will pretend that he's Caesar and then take care of things. So that the curtain falls at the end of Act 1 with the nod being given to the Madison entourage rather than the New Jersey entourage, that we seem to be going in the Madisonian direction, although Madison is not getting all his way. Act 2 enters, and with Act 2 we get the New Jersey folks fighting back. And they fight back, and they fight back for 2 whole weeks. And the convention is held in sort of balance with actually going nowhere at all. Until at the end of June, Ellsworth from Connecticut says, I've got a breakthrough. It's not, are we national or are we federal? Are we people-based or state-based? We are partly national and partly federal. We're a mixture. We're thinking outside of the box. So we can be partly national with people and rights and powers, and we can be partially states with rights and powers. Madison is furious. A committee is created known as the Jerry Committee, and they issue a report suggesting precisely that compromise. And that is passed on July the 16th. And the curtain comes down at the end of Act 2 with a fundamental compromise built in. And states' rights now are clearly part of the fabric of our discussion because the states are now represented, each state 2 votes in the Senate. And the state legislatures elect the Senate. The people elect the House, the states elect and are represented in the Senate. That's the Connecticut Compromise, the House and the Senate. Right. And they take an intermission, and you say, Lloyd, this is going too far. This is carrying this Act 4 Act drama out now. You got an intermission. Yes, there was an intermission. A committee was created. They took a leave. They sat down, and they came up with the first draft of the Constitution. And the first draft of the Constitution is known as the Committee on Detail Report, Act 3. And this outlines the basic Constitution. I mean, it's not there yet, but they outline it. And what they do during the month of August, the delegates, they go through this document, paragraph by paragraph, clause by clause. And this is the time that the powers are enumerated. This is the first time you'll see the enumeration of powers. And right around this time, Mr. Pinckney, on, was it August the 20th? Is it that? Mr. Pinckney, is it there? Yeah, Mr. Pinckney on August 20th makes a suggestion. He says, included in his list are liberty of the press, restrictions on the removal of the writ of habeas corpus, subordination of the military to the civil power, and no religious test or qualification shall ever be annexed to any oath or office under the authority of the United States. And those proposals were sent back to the committee in detail. The only one that was acted on was that last one, that no oath or religious test shall be taken for office. And you could say, well, why does it occur in Article 6 of the Constitution? Why right at the end of the Constitution? And the answer is because most of the rest of the Constitution had already been worked out. And they agreed to this. So the Anti-Federalists have something really going here, because it was possible to include those, like liberty of the press and stuff, but they weren't. And that really leaves a big question mark. So Pinckney did propose it during this period of time. All right. And only one was accepted, as I mentioned. At the end of August, they were pretty close to being finished. Still no Bill of Rights, strictly speaking. And a committee by the indelicate name of the Leftovers Committee was created, also known as the Brearley Committee, after Mr. Brearley. And this committee had to deal with what was still to be done. And the most important thing yet to be done was the creation of the presidency. It had gone around and around and around on it. Shall we have one president or two? Well, I can't answer that until I know how the president is elected. Well, I can't answer that until I know how long the president is going to serve for. Well, I can't answer that until I know what the power of the president is. Well, I can't know that unless I know whether the president is impeachable. Well, I can't answer that until I know whether there's one or two presidents. And around and around and around they go. And so this is the group at the end of August, beginning of September, who create the Electoral College as the way in order to sell this. Now, many people consider the Electoral College to be a violation, not a violation of a Bill of Rights, but somehow a violation of our rights. And the answer is, only if we're supposed to be a nation of people, if we're supposed to be a nation of people and a nation of states, it is not a violation of the rights of states. But that's the problem. To what extent do this issue of our individual rights gets mixed up with the issue of the rights of states? And how does that play out? And the answer is, it doesn't play out in Europe. You don't going to get that from the English and colonial tradition. You're going to get that straight from this new American phenomena called a republic, a federal republic, state-based republics under one big, huge federal republic. And how do you distribute things? And because, by the way, those Bill of Rights that we just went through in the second session, they're still there in Virginia, still there in New Hampshire, still there. They haven't gone away. The question is, do we want to have a federal one as well, a U.S. one as well? And that's been what we've been talking about right today. So this Committee on Style finishes off the job, and then it's submitted for signature on September the 17th. That's Act 4. The end is in sight. And right near the end, on September the 10th and the 12th, there in our push, let's see, Randolph articulates his difficulties. Randolph says, you know, I introduced the plan in the beginning of the Virginia plan, but I have difficulties now. And that is, I think that we should go to the states for ratification, but really provisional ratification, like a straw vote. Why don't we have like a focus group for 13 states and get their opinion and come back? And Madison would say, one miracle in Philadelphia is enough. You can't get two miracles in Philadelphia, right? And so part of what Madison is going to try to do is to head off the call for a second convention. And we'll see that after lunch, that whole, how that factors in to the the way in which the U.S. Bill of Rights takes final shape. I mean, this morning we've been doing more with the origin. This afternoon we're going to do more with the politics. So they've got the origin and the politics of the Bill of Rights that we'll be looking at. But you can see then on September the 12th, right near the end, 1 week before the end, less than 1 week before the end, Mason from Virginia and Jerry from Massachusetts suggest that what we need is to attack, to preface, notice the word they use, call for a prefatory Bill of Rights. This motion is defeated 10-0. And it's a difficult moment there because, as you can see, it says Massachusetts is absent, but it can't be totally absent because Jerry's there for Massachusetts. What it means is that not enough people from Massachusetts were on the floor for Massachusetts to vote. That's what that means. But the point is that right near the end, and Mason uses the language, it won't be too difficult for us to come up with a Bill of Rights because all we have to do is to copy Virginia. By the way, I wrote it. With the exception of the final one on Virginia was done by Madison. 25-year-old Madison came up with the conscience one. The rest was Mason. And that's where I think it's sort of we start the shift from the idea of the Bill of Rights as a documentary history from Magna Carta through the Northwest Ordinance and how the convention dealt with it into the politics as we start moving into ratification and the first Congress and the adoption of the Bill of Rights. That's sort of the move. And this becomes very, very important with the Anti-Federalists because George Mason, why not do it? I mean, what have you got to lose? And Madison is insistent that he does not want the Constitution to be loaded down with parchment barriers that don't work. The only thing that works is checks and balances, separation of powers, scheme of representation, an independent judiciary, and a large extended republic. Those are the five concepts that Madison is emphasizing, or I'll repeat them. Legislative checks and balances, separation of political power, an independent judiciary, a scheme of representation, and an extended orbit. Don't talk to me about bills of rights to protect rights. They don't work. The Constitution is a Bill of Rights. And that's where we end this session, except for questions.
I have a question about privileges and immunities, the clause.
Yes.
You didn't talk much about that, but I thought that if my understanding is correct, the privileges are, as an oath-taking member of the covenant or the social contract, the citizen can express some reserved political rights. Does that work? Something like that?
It's not an easy concept to explain, but it's usually linked within the American context with travel. So, for example, the privileges and immunities clause, there is a privileges and immunities clause under the Articles of Confederation. So as you move from one state to another state, and in the Constitution under Article 4, where what one state owes another state. So what we might call horizontal federalism. Article 1, Section 8 in the 10th Amendment is a vertical federalism. Washington and the states. What one state owes another state, horizontal. And the big issue now is gay marriage from one state to another state. So privileges and immunities, as I understand it, is like Americanizing the rights of Englishmen so that when you leave England, don't you travel with some rights? That's how I understand the privileges and immunities clause. And exactly what is in there it's difficult to tell because it's left vague.
So then the immunities were certain contracted limitations on government power?
Yeah, I'm following what you're... privileges and immunities would mean, I repeat, what rights do you travel with? What are your expectations, your reasonable expectations? What can you... I mean, like you have an office. Do you have... What expectation of privacy do you have? Right? Do you have a privilege of privacy, an expectation? Are you immune from prosecution under certain conditions? And how do you acquire immunity? It's like you're immune from incriminating against yourself in a court of law. So you're immune, or a judge can grant you some immunity. You say, I don't want to tell on my brother and sister. Well, we won't. We'll grant you immunity. That's how I understand it. It's certain rights that you acquire. They're not natural rights. They're more like common law, travel, expectation, situational.
So they would have to be expressed through statutory law as opposed to fundamental laws.
Fundamental laws meaning a constitutional law? Yeah. I think they have to be fleshed out by statutory law.
Because my understanding is that's what Madison said was enough. Is what he said that the privileges and immunities should be enough.
To do what?
Well, that's why we didn't need a Bill of Rights.
Oh, I see what you mean. Well, that'd be interesting. That's not my understanding. By the way, this smart aleck, I haven't seen in 23 years. This former student of mine at University of Redlands just decides to come up and give me a hard time. See, I know what I'm talking about. Now, what my understanding of privileges and immunities from Madison is that even with privileges and immunities, it's not going to be enough to stop a determined, dedicated majority. Because you can wave your piece of paper with a statute or constitutional and say, here are my privileges, here are my immunities, and they wouldn't be worth the paper it's written on if the majority is determined not to observe them. So it could be that Madison says that would be enough. Why we don't have to do any more, but I guess my point is that even that's not going to be enough. You're going to have to, in a Federalist 10, the idea of what you need to do is to spread the people out so they don't discover their nastiness. And then when they do discover their nastiness, you make it more difficult for them to act on it. So that Madison, in this regard, would be arguing against the small, intimate, hands-on university, where parents pay thousands of dollars to get that intimacy. I mean, why? I think Madison would say everybody knows your business. Thus, you don't have that privacy. You don't have the privilege of privacy, and you're not immune from people poking their nose in your affairs in the name of doing you good.
It's almost like the movement from citizens to statesmen, from Sam Adams to John Adams, and back again, and the importance of recognizing both in the process. Madison represents a movement to a type of a republic away from the citizen, and yet the Bill of Rights is a pull back to the original reasons for the revolution to begin with.
So you're suggesting that Madison is moving away from a traditional understanding of republicanism.
He's less in touch with the individual, as opposed to someone like Sam Adams or Patrick Henry or any of the anti-federalists who are so crucial and important in the unification, the unifying spirit of the revolution. And he's gone beyond that, and to some extent, although he's a product of it, he's distanced himself, and yet they pulled him back in.
You mean in the 1790s? Later on, he becomes like a semi-anti-federalist again?
They're distancing themselves from the experiences. It's interesting that this group all fought and were very familiar with one another and had unified themselves.
Yes.
And upstands, upstands Washington and upstands Franklin, and then all the other little players. I wouldn't really call Hamilton necessarily a little player, but they're all assembled. And then you have Adams from the family, and there's just a huge history of the rights of the citizen, the disenfranchised.
Well, that's an interesting way of doing it. As you're talking, I'm thinking here, and I certainly, by disposition and by passion, Adams and Sam Adams and Patrick Henry are more sort of revolutionary inclined in terms of fireworks and whatnot. And you can, I can imagine sort of like revolution and permanence, that kind of, you keep it stirred up, that kind of thing. And when I think of Madison, I don't think of that stirring up. I think of moderation, and it'd be like constitutionalism and permanence. That checks and balance and permanence. That'd be sort of like bore you to death in permanence.
But his wife represents the citizenry. They're pulling him back into
Dolly?
They're pulling him back into the reasons for the Constitution.
Well, that could be. I hadn't thought about that. I can certainly understand why you could have revolutionary parades and firecrackers for Sam Adams and Thomas Jefferson and Hancock and the rest of it, but I can't see that for Madison. I think Madison, what do you want? Moderation. When do you want it? Now and again. I just don't see. Madison. You go to Virginia, you have Patrick Henry Highway, Patrick Henry Airport. You have to search after Madison. So Madison is much more the scholar, right? And Patrick Henry and they're much more you call it the citizen. I think they're looking at different problems. I think Madison looking at the problem of governing. How do you make a well-constituted republic work? It has never before in the history of the world worked. No government has lasted forever, and popular governments are terrible. And all this talk about rights with parchment barriers, we need to be realistic.
The entrepreneur versus the manager.
Yeah. But who is more entrepreneurial than Madison when it comes to the creation of the Constitution?
Which is the culmination of all of those people's work, as he acknowledges.
Yeah. So your point, I gather, is that Dolly and the rest of that crowd keep Madison honest with regard to citizenship.
Can you think of Madison without Dolly?
Yes. I
Shame on you, sir.
I, I hardly think of Dobby, actually. I say, hello, Jimmy. No, good point. I don't know. By my response, I'm trying to work it through. I hadn't thought of that before, so I'm still trying to work it through.
All right. Well, with that, let's wrap up session 3. Thank you, Professor Lloyd.
So we'll be back when?
We'll be back in here at 1:15.